Hello, everybody, and welcome to No Crime, No Time Community Chat. Today we're going to talk about June 25th, 2020, Zellner's response. And it's going to be a cold read for me. I have been crazy busy. I want to say, hi, Karen Chaos. How are you? Thanks for being the first one on the chat. Hi, Mary. How are you? Good to see you. So you guys, let's get going here. I don't want to waste a lot of time because I have to work today. I've been putting in some long hours. Before we jump into this, I'm going to take just a few minutes to kind of give you guys an update. I want to thank all of you that have emailed me or DM'd me or Twittered me to just check on me, make sure I'm doing okay. It warms my heart. It really does. Gretchen, quit itching. I do have a lot going on. I'll just give you a very brief idea. I've had a family member, like major members, adjust in our household. So we have teenagers that, not to get too complicated, but we had to rearrange to make room to help people out. And in that process, my ex from 8 years ago, who we haven't talked forever, kind of started talking again, so I got that going on. I have my bedroom tore apart because we're remodeling it and we're at the painting stage. So I'm sitting on the edge of the bed here and I'm holding I found my mic. So hopefully you guys can hear me all good. I'll ask for a sound check, please. And I want to say hello to a few more people before we get rolling. So, hey, Teresa, good to see you. And Julian Dyer. And Shane Henry. And DJ So Cool. And Beverly Heineck. Hi, everybody. And so, like I said, this is going to be a completely cold read, but if I'm going to have to read this thing, because I feel like Zellner's got this in the bag anyway from the tweets and following AC on Twitter, who does hats off to AC. He's been doing a fantastic job of really calling out parts of it that really are relevant, but it looks to me from what I'm hearing out there that Zellner pretty much, how do I put it? I think somebody else worded it really well. Can't remember who, forgive me. But they said something along the lines of the state would be better off just forfeiting right here and letting Stephen and Brendan walk. So I have a lot of hopes to hear this. Teresa says can hear good or can hear great. And Mary says can hear fine. Thank you, ladies. We have another person joining us, and that's Pseudo DNA. Yes, I'm glad you got to join us on a live. Hey, Wabla, good morning to you. And welcome, Ashley Holt and Sherry Lynn Pontello. All right, the rest of you, I'm going to catch you when we come back up to topside. Because I have to work today, I really want to get on this. So let's jump over. I'm going to do a visual check. Yep, we got to get that rolling so you guys can see it. Good thing I did a visual check or you'd have been looking at the same page forever. Okay, let's see. How do we do that? Yay. Okay, let's go back over and do one more visual. Yep, we're good to go. All right, so this is in the state of Wisconsin Court of Appeals District. I think that's a JJ or FF. I don't know. Okay, we have Kathleen T. Zellner and Stephen G. Richards. Let's jump all the way to the introduction, which is going to save us some time. Introduction. Stephen Avery, Mr. Avery, has spent 5,343 days, which is 128,232 hours behind bars for his second wrongful conviction. He has endured the mental anguish of knowing that he is innocent and his constitutional rights to a fair trial were violated. 1 minute. I've got to move my puggy because she's snoring again. Maya, come here, baby. I know Mama reads and you sleep, but that gets to be a little much for the people that are listening. I didn't realize she was in here. She just came back from the vet because she had an abscessed tooth. So she's on pain meds, but she'll be fine. She's got her bed. And continuing, the state, in desperate effort to keep Mr. Avery in prison, devotes 104 pages to arguing that Mr. Avery's claims are procedurally barred. However, the state ignores the most important undisputed fact that refutes its entire argument, that Mr. Avery is procedurally barred from bringing his new claims. There was an agreement on September 18, 2017 between the state and Mr. Avery that Mr. Avery could amend his June 2017 974.06 motion without opposition from the state, perform additional scientific testing, and schedule a 4-week evidentiary hearing if needed. Proof of the argument is evidenced by the undisputed fact that the state did not object to Mr. Avery's October 6, 2017 motion to vacate the October 3, 2017 court order dismissing his June 2017 974.06 motion. The circuit court also recognized that the state and Mr. Avery had made an agreement as described above. Because of the undisputed agreement between Mr. Avery and the state, hold on, something's not letting me scroll. Let's try this again. Well, I do have it downloaded. There we go. Oh, now it gives us everything. Hold on. Sorry about that, guys. Computer froze. Where were we? It jumped like way ahead. We'll just start here. The circuit court also recognized that the state and Mr. Avery had made an agreement as described above. Because of the undisputed agreement between Mr. Avery and the state that he could amend his June 2017 974.06 motion, all the state's current arguments about Mr. Avery being procedurally barred are waived, and the state should be estopped from raising the procedural bar agreements. Arguments. The circuit court orders are replete with legal errors, as the state points out in the state's brief 1720, 102, 103, 104, and 108. Because of its legal errors, the circuit court failed to address many of the issues Mr. Avery raised, so there is no record of those for this court to determine whether the circuit court erroneously exercised its discretion. In fact, it is an erroneous exercise of discretion to fail to exercise discretion over multiple issues. Alternatively, if this court engages with the state's arguments, Mr. Avery presents sufficient reasons why his claims are not procedurally barred, including the 2 supplements to his June 2017 974.06 motion allowed by this court, which conclusively defeat the state's claim that successive and non-supplemental motions were filed. Additionally, Mr. Avery presents Brady and Youngblood claims discovered after his June 2017 974.06 motion and new evidence, which are not procedurally barred. At trial, the state's primary witness, Bobby, committed perjury when he testified that Miss Halbach never left the Avery property and that he was asleep when he was doing internet searches. He has direct connection to the murder by his subsequent admissions, violent pornography, and word searches that reflect knowledge of the crime and the victim, motive, and opportunity to commit the crime and plant evidence against Mr. Avery, including bones from his burn barrel and blood from Mr. Avery's sink. Trial defense counsel failed to hire the necessary experts and failed to investigate and establish third-party suspects pursuant to State v. Denny. Most importantly, the state's primary witness, Bobby. Prior post-conviction counsel was ineffective in all the same ways. Current post-conviction counsel has uncovered numerous Brady and Youngblood violations, the cumulative effect of which undermines confidence in the verdict. The state's brief fundamentally misunderstands the basic facts of the case, the, quote, law of the case, effect of the supplements that this court allowed, the effect of the circuit court's legal errors, and the estoppel effect of the 2017 agreement between Mr. Avery and the state. Introducing argument. Part 1. The state is estopped from bringing procedurally barred claims. In Wisconsin, the doctrine of judicial estoppel is used to prevent litigants from playing fast and loose with the judicial system by maintaining inconsistent positions during the litigation. Specifically, judicial estoppel precludes a party from asserting a position in a legal proceeding and subsequently asserting an inconsistent position. Argument that it does not matter what the parties agreed to. The state's prior agreement with Mr. Avery's counsel utterly disqualifies the state's procedurally barred arguments. the focus of the state's brief. The state is estopped from entirely changing its position in arguing that Mr. Avery is procedurally barred from raising his claims after it agreed that Mr. Avery could amend his motion, conduct additional scientific testing, and, if needed, schedule a 4-week evidentiary hearing. Judicial estoppel applies to the party positions, not that of the judge. A reviewing court determines de novo whether the elements of the judicial estoppel apply to the facts of the cause. 3 elements are required for the court to invoke the doctrine of judicial estoppel. Number 1, the latter position must clearly inconsistent with the earlier position. Number 2, the fact at issue should be the same in both cases. And number 3, the party to be estopped must have convinced the first court to adopt its position. ID, Mr. Avery meets all 3 elements for the following reason. Number 1, the state's current position that Mr. Avery is procedurally barred is clearly inconsistent with the state's September 18, 2017 agreement with Mr. Avery that he could amend his petition. Number 2, the facts at issue are the same before the court and the circuit court. Number 3, the state, by not objecting to the existence of the agreement described in Mr. Avery's motion to vacate, convinced the circuit court that there was, in fact, an agreement. The state failed to object to Mr. Avery's motion to vacate. The state had the opportunity to object and failed to do so when Mr. Avery submitted his 974.06 motion to vacate on October 6, 2017, which described the agreement for amending his motion, conducting additional scientific testing, and scheduling a 4-week evidentiary hearing if necessary. In his motion for relief from judgment, Mr. Avery specifically pled, on October 6, 2017, current post-conviction defense counsel spoke to prosecutors and informed them that this motion would be filed today to vacate the order. This motion has been presented to and reviewed by the prosecutors, and the prosecutors agreed to the factual accuracy of the representations regarding the content of the September 18, 2017 meeting made in the motion. When current post-conviction counsel asked whether the circuit court should immediately be informed of the argument, prosecutor Fallon stated that once he had finalized the scheduling of the RAV4 examination with law enforcement, a stipulated order could be presented to the circuit court, similar to the original stipulated order for independent scientific testing entered on November 23, 2016. Mr. Avery relied upon the agreement with the state and the state's request for additional time to schedule the testing of the RAV4. By not objecting to Mr. Avery's motion to vacate, the state has waived this argument on appeal. The state should be estopped from changing its position now. Mr. Avery relied upon the state's representations that it agreed to allow him to amend his motion, conduct new scientific testing, and reschedule a 4-week evidentiary hearing if needed. So let's take a breather there. I'm going to come back up to live stream. And let's see here. How's everybody doing? We'll just take just a second. I'm going to scroll back up and see who else has joined us. Hey, Dark Side of the Moon, excellent to see you. And Andrea Merritt, good to see you. Glory Glenn, I always have a trouble. I'm just going to say Gloria G. Hi, everybody. Good to see you all. Nomadic Slavic is with us. Hi. All right, guys. So let's read we'll pull out a couple opinions. Wobla says, I think the only way out of this is going to be a retrial with full subpoena on all Denny aspects and a chance for evidentiary hearing at the same time. 7th Circuit are acting not interested. DJ So Cool says, I absolutely agree with Wobla 100%. Gloria also agrees with Wobla. So that's about it. We need an evidentiary hearing, there's no doubt. So far it looks really good to me. I'm very impressed with the fact that the way it's worded, there's really no wiggle room for interpretation on what is legal and what is not. And the fact that the state went into actual legal agreement with Stephen to allow him to amend and come back and pursue new scientific testing, and that they were the state was basically saying we have to do our testing first. Those are all very solid points that Zellner makes, and they do seem to fit the 3 criteria very well. So I don't think there's a lot of wiggle room that we have the right, like a constitutional right, to continue, and that how can it be procedurally barred if you just got done hearing in 2017? Yes. And part of that criteria is that it be, if it's inconsistent, that's one thing, but it's the state being inconsistent, not Stephen Avery or post-conviction counsel. Sherry Lynn Pontello says they would never make it into new trial. KZ would rule out all the evidence pre-trial, and they would have to drop charges. Oh, so true. All right, guys, with that, let's jump right back in. We're going to do part 2. I'm sorry I'm being so quick, but I got to get to work later, so I want to make sure we get as far as possible. This might be 2-part where we finish it tomorrow, but we'll try to do our best today. It will be probably 2-part, though. Part 2, the state's erroneous application of the fundamental I cannot talk. We're going to start over. Part 2, the state's erroneous application of the fundamental principles of post-conviction review. Pleading standard. The state argues that Mr. Avery must affirmatively allege that his facts were sufficiently pled, which is not the actual standard. The proper standard is from State v. Allen, which Mr. Avery satisfied in his brief, even presenting a chart for greater clarity. Standard governing a petitioner's right to an evidentiary hearing. The state argues 13 times that Mr. Avery failed to, quote, prove his facts and, quote, disprove the state's cause or case. But see the state's brief, page 23, conceding that, quote, an evidentiary hearing is a forum to prove factually supported claims. The standard is that the facts must be assumed to be true in determining whether to grant an evidentiary hearing. State v. Bentley. The state fails to assume Mr. Avery's facts are true, as the standard requires. The state reverts to the, quote, sufficiently proven standard, which does not exist. Mr. Avery is not required to prove the facts supporting his claims before this court. The state's brief inadvertently concedes the need for a hearing by creating numerous factual disputes in arguing and weighing the evidence. See factual dispute chart infra. Ironically, the state uses the term conclusory 25 times in a conclusory fashion to describe Mr. Avery's arguments without explaining what is conclusory about them. Quote, a post-conviction movement need only provide sufficient objective factual assertions to be entitled to an evidentiary hearing. That is, a movement need not demonstrate theories of admissibility for every factual assertion he or she seeks to introduce. Love, 2005, Wisconsin. Part 3. Mr. Avery's claims are not procedurally barred. Mr. Avery is not procedurally barred by his 2013 Pro C 974.06 motion. The state argues Mr. Avery failed to show sufficient reasons for not raising his June 2017 claim in his 2013 Pro C motion, arguing that Mr. Avery, indigence, and lack of legal training were not, quote, sufficient reasons. The state's brief claims, quote, Avery's assertion that he was incapable of recognizing and raising legal claims was demonstratively false. The circuit court remarked that Avery's Pro Se motion recognized sufficient legal issues which the court previously ruled on. However, the circuit court's recent opinion is disingenuous because the circuit court previously ruled that Mr. Avery's claims in his Pro Se motion were, quote, unsustainable or unsubstantiated, quote, empty and without substance, quote, completely meritless, quote, bordering on frivolous, and, quote, wildly speculative. Miraculously, the state has transformed Mr. Avery into a legal scholar to serve its own purpose. Pause right there, you guys. Stop right there. Savor that. Miraculously, the state has transformed Mr. Avery into a legal scholar to serve its own purpose. Okay. Think about this, you guys. They transformed Stephen into a genius where he was able to clean all evidence except for evidence that incriminated only himself, and erase all DNA evidence of a victim, but then leave the patina, the time-induced oxidation on and dust particles in the room, as if nothing had touched it. Right? Now they're trying to turn Avery into a scholar. I mean, didn't they say that they felt this gentleman had such a low IQ that he didn't know any better than to call actually Auto Trader rather than just Teresa? That's why he would do that? I mean, he's either dumb or he's a genius. The state is doing this. They are making this appear that whatever they want to victimize Stephen as and call him, that's what they try to build. It's like all the locals that talked about this, they from Calumet and Manitowoc, they said that those counties, and now we see the state doing this, they say that the counties basically write false reports that build a certain image, a certain storyline, and then they go and they mold that person to fit that report. And that's what they've done in their last response, in my opinion. What do you guys think on that? Let's jump over here. Let's see. Hey, Andrea Merritt. She says, I agree with them. Just retry the whole damn thing with KZ in his corner. Him having has gone on long enough. They had plenty of time to test whatever they wanted. They're sitting on it. Mary agrees with that. Wobla says, Andrea Merritt, I agree, but I wouldn't have an evidentiary hearing in advance of retrial. True. Gloria says, will they ever be held accountable, though? Gloria, that's a great question, and I think we all battle this feeling of getting up in the morning and thinking, well, okay, we're going to get on here. We're going to do everything we can to bring awareness to the wrongful conviction and all the lies and the bad faith, I guess Zellner calls it. I call it just malicious intent to frame someone. And we go, when is somebody going to actually get called out for this legally? And the problem is, this is so corrupt. It's on such a big level that when you start climbing the rungs on this ladder, you can already see back in years ago, you guys, when I would whisper, I think the state of Wisconsin's the one kind of helping this along, I would get boo-hooed away, and people would drop me and not subscribe. So now we're at the point where you're all awake. The state is absolutely throwing this whole situation into the same blueprint that the county did. So now you have to look at it and go, wait a minute. Even apart from the Steve Avery case, there's so many people that live in these small communities and we blame only the county. But if you really look at the head of the spider, right, we often find that the body of those legs of counties is the state. And then who's the head, you guys? I'll let you think on that. Look around at what we got going on. We're basically finding out that our government was funding all kinds of propaganda to be fed to us through, and I'm talking federal level, through this whole pandemic and everything. We're finding out that it was just terribly misconstrued and that it's fake news, right? Well, who prepared us for that? Ken Kratz back in 2005. Ken Kratz seems to have highlighted fake news and he used the media to convict Stephen. And I feel that that's what the state's doing, is they're trying to pull the wool over the sheep's eyes here and get away with basically murder, because eventually these two individuals that are wrongfully convicted are going to die in prison if we don't get them out. So, okay, let's get back over to this. I know I'm just rambling. Sorry. I just miss you guys and getting to talk about the case. And Mr. Avery has demonstrated sufficient reason throughout his brief in supporting affidavits. Affidavits are considered part of the pleading. The Wisconsin Supreme Court found that an affidavit was not insufficient to make a valid claim for newly discovered evidence, reasoning that, quote, a movement need not demonstrate the admissibility of the facts asserted in the post-conviction motion, but rather must show sufficient objective, material, factually assertions that, if true, would warrant the movement to relief. Emphasis added. The state misinterprets Mr. Avery's argument to conclude that Mr. Avery's claims were available to him since 2013. In 2013, Mr. Avery lacked legal knowledge, had cognitive deficiencies, and had no way of knowing the factual and legal basis of the claim in the instant appeal. Mr. Avery's 2013 pro se motion demonstrates this, as none of his 11 issues were meritless or could have possibly raised the subsequently discovered Brady, Youngblood, new evidence, or ineffective assistance of counsel arguments. He had no way of acquiring knowledge of the factual or legal basis for his current claims. The state concedes that Mr. Avery's pursuant of his pro se petition was diligent, but he failed despite his diligence. The fact Mr. Avery in 2013 was diligent despite the unavailability of the necessary information supports his position. Where the Supreme Court found that the habeas petitioner was entitled to an evidentiary hearing on a jury bias claim since he was diligent in his efforts to develop the facts. Because Williams was not on notice of the jury bias issue, the Supreme Court found that Williams did not fail in his duty of due diligence. The Supreme Court held that unless there is a lack of diligence or some greater fault attributable to the prisoner or the prisoner's counsel, a failure to develop the factual basis of a claim is not established. Applying Williams, Mr. Avery did not fail to assert claims of which he had no notice. Further, as in Williams, Mr. Avery's claims were unavailable to him, even if he did have legal knowledge, because they were based on evidence withheld by Brady and Youngblood violations, discoverable by only expert examination, not pursuant or recognized by his prior attorneys. Because Mr. Avery is a learning disabled indigent prisoner, he simply could not have been aware of the factual basis of his claims. The Wisconsin Supreme Court has also found, quote, sufficient reason where the movement lacked factual awareness of his claim, State v. Allen. Even if Mr. Avery knew he needed experts, he could not persuade any experts to assist him. Therefore, he could not have known that the blood had been selectively planted in the RAV4. The bullet fragment, number FL, had wood and not bone embedded in it. The hood latch swab never swabbed a hood latch. Mrs. Halbach's sub key could not have fallen from the bookcase, and the subsequent discoveries of numerous Brady and Youngblood violations. Mr. Avery wrote to dozens of attorneys, all of whom rejected his requests after his direct appeal was denied. Mr. Avery also wrote laboratories that would not respond unless he had an attorney. Mr. Avery described the impossibility of his efforts to get experts due to his pro se status, not lack of awareness that he needed them. The circuit court should have granted an evidentiary hearing on Mr. Avery's allegation that he lacked the factual basis in 2013 to make the current claims. Significantly, the state ignores State v. Anderson, 2013, Wisconsin, which Mr. Avery relied upon in his June 2017 974.06 motion. In Anderson, the defendant, like Mr. Avery, argued that his cognitive deficiencies provided a sufficient reason for not raising certain claims prior to his 974.06 motion. The court was skeptical of Anderson's claims regarding his disabilities, but the court assumed Anderson's disabilities excused his failure to raise the claims earlier. ID. Applying Anderson, Mr. Avery is not barred from raising his claims because he raised several sufficient reasons, including his cognitive deficiencies, impossibility of hiring experts, and lack of factual and legal awareness, for explaining why he could not raise his claims in 2013 motion. The circuit court failed to rule on prior post-conviction counsel's ineffectiveness. The circuit court failed to address prior post-conviction counsel's ineffectiveness because it applied the wrong legal standard. The circuit court stated, a circuit court is not authorized by statute to resolve claims of ineffective assistance of appellate court or counsel. State versus Knight. In this matter, if the defendant wishes to pursue the claims regarding his appellate counsel, the defense may file a Knight motion with the Court of Appeals. Wisconsin law requires a defendant to present a claim of ineffective assistance of post-conviction counsel to the trial court in the first instance. See State XLREL. A Knight petition is only appropriate for claims of ineffective assistance by appellate court. Because Mr. Avery alleges ineffective assistance of post-conviction counsel, not appellate counsel, the circuit court improperly refused to rule on his claim. The state acknowledges that the circuit court, quote, was wrong about the law of post-conviction procedure because, quote, confused the procedure for raising ineffective assistance of post-counsel with the procedure for raising ineffective assistance of appellate counsel when rejecting the claim. However, the state argues that if the trial court reaches the proper result for the wrong reason, it will be affirming, citing State versus Holt. Holt is distinguishable from this case. Holt involved the trial court's decision to deny a jury instruction. The appellate court found that the trial court's refusal to give the instruction was proper, even though the trial court's reasoning was incorrect. Unlike Holt, where the record was sufficient to resolve the issue, in Mr. Avery's case, there is no underlying record or discretionary decision to review because the circuit court failed to rule on the issue. Because the circuit court applied the wrong standard and believed that the appellate court had to address the ineffectiveness of proper post-conviction counsel, it did not evaluate the substance of the claim, nor create a record for the court's review. State differentially, the record lacks any discretionary decision for this court to review. The appellate court remanded an issue for an evidentiary hearing because the circuit court failed to make a discretionary decision. So there was no record of decision for the appellate court to review. In Mr. Avery's case, in addition to failing to create a record for this court to review, the circuit court abused its discretion by refusing to rule on his ineffective assistance claim. Quote, the failure to exercise discretion is an abuse of discretion. In State versus Kunze, when faced with a similar legal error by the trial court that resulted in no record for appellate review, the court held, quote, if the circuit court is able to conduct an adequate retrospective hearing, it shall do so. Therefore, in the instant case, the court must hold an evidentiary hearing about the allegations of prior post-conviction counsel's ineffectiveness. Mr. Avery pled sufficient reasons for failing to raise prior post-conviction counsel's ineffectiveness in his pro se motion. The state argues Mr. Avery fails to establish a sufficient reason for not including his current ineffective assistance of prior post-conviction counsel claim for his pro se direct appeal. Mr. Avery not only alleged a reason, he has demonstrated, quote, sufficient reason consistent with Wisconsin Statute 974.06. I can't do this hardly today, you guys. I think it's because I'm sitting on my bed. And I'm like, every move I make, I bounce a little on the bed. And I'm like, where am I? But it's because my room's being reconstructed. Okay, you guys. What constitutes a sufficient reason pursuant to state Wisconsin statute is determined on a case-by-case basis. The Wisconsin Supreme Court has held that ineffective assistance of post-conviction counsel may constitute a sufficient reason. Mr. Avery's pleading alleged sufficient facts for his claim of prior post-conviction counsel's ineffectiveness. Mr. Avery alleged sufficient facts about prior post-conviction counsel's ineffective failure to hire experts, conduct a significant investigation, or review discovery regarding potential third-party Denny suspects to warrant an evidentiary hearing. Clearly, prior post-conviction counsel recognized the need for experts on Mr. Avery's behalf because they asked the court for an extension to retain experts, stating, quote, counsel would be remiss if they did not consult with scientific experts on matters beyond their own knowledge and expertise, just as counsel would fail to satisfy their ethical obligations if they did not pursue potential leads for post-conviction relief. emphasis added. Despite recognizing the need, prior post-conviction counsel did not retain any experts. The pivotal question is whether Mr. Avery's 974.06 motion is sufficient to entitle him to an evidentiary hearing where he would have had the opportunity to show that his trial and prior post-conviction attorneys rendered ineffective assistance of counsel. Determining whether counsel's performance was deficient requires the court to, quote, focus on counsel's perspective at the time of the trial or post-conviction. This determination often cannot be made without counsel's testimony, without which a court cannot, quote, focus on counsel's perspective and, quote, cannot otherwise determine whether counsel's actions were the result of incompetence or deliberate trial strategies. The court held, assuming there are factual allegations which, if found to be true, might warrant a finding of ineffective assistance of counsel, an evidentiary hearing is prerequisite to appellate review of an ineffective assistance of counsel issue. This court must assume as true trial defense counsel's Strang's affidavit that Strain and Beauty were ineffective in that they failed to hire ballistics, trace, and blood experts. The court must also assume that trial defense counsel were ineffective in failing to investigate and impeach the state's primary witness, Bobby, at trial, as evidenced by their investigator's affidavit. Additional trial defense counsel was ineffective in numerous other ways. Okay, before we start part 4, I'm like getting tongue-tied, so I need a drink. I'm going to come up and we'll do a little talking. By the way, good to see you all. Let's see here. Gloria says, Fallon said innocent people don't confess, and now he's on sabbatical. So, right? Dark Side of the Moon agrees with Teresa. Teresa says, Andrea, you know why they didn't test it? It would have matched Stephen. So let's go back up. Teresa says, oh, where are we? It's going by pretty fast. Hold on. Let me sling up here. Sherry Lynn Pontello says a lot of the DNA evidence could get thrown out because she claims later it was all swapped around. Yeah, they're good at swapping. This, the state's really good and the county's really good at relabeling and repackaging. I swear, it's like Calumet and Manitowoc must have worked for eBay. They are constantly getting this stuff out of the bag, handling it, cross-contaminating it in this little tin shack they got set up near the Avery property. Not only that, they're bringing in, the suspect and the victim's DNA into the same establishment, and yet the sheriff himself, and this is where I find this very negligent, the sheriff himself stated he did not want, I believe it was the Sheriff Pogel, that he did not want or could not allow the RAV4 and Stephen Avery, so the RAV4 being the victim's vehicle, and the suspect's vehicle in the same trailer because of cross-contamination. Yet, they're going to go into the victim's home, collect the DNA evidence needed to identify the victim, and they're going to bring it to the same tiny little, probably 10 by 20 foot trailer that they've got parked as their mobile crime unit, and they're going to introduce both the victim and the suspect's DNA on the same tables. And then you listen to Sherry Culhane, the state's expert, the tech that was the one that handled it in 1985 and basically convicted Stephen Avery with her testimony, stating that this pubic hair matched Steve Avery. Later, we find out that no, it didn't, and that she sat on that for another year just to, because she didn't want to do an email. They're all swapping. Their swab reminds me of Dora the Explorer, like, no swabbing, no, it's like, no swiping swiper, no swabbing swiping, they just are stupid. They're switching up the growing swab and pretending that they're throwing it in the garbage, but they're using it to convict the person. And if it was all on the up and up, if the person really committed the crime, none of that shit would have happened, right? Because it would have just been a crime. They would have found the DNA that showed it was a crime. They would have found DNA of the victim all over the place. There would have been a murder scene, I've tried to think about how Stephen could have committed this crime in so many ways. First of all, he was on the phone all the time. He was having people over at his property. He's being seen by several different people throughout the night. He's talking to people, and also he would have to be an expert to get rid of all the victim DNA, but leave his own DNA. Only put his DNA on the important parts of stuff that you know they're going to find. Not get rid of any evidence, but yet be able to get rid of all the victim's DNA and put the dust back on. Jackhammer they have to jackhammer the floor in the garage, and yet we find a bullet that has no patina and no residue at all on it, which is against scientific fact. So we know all this crap. We all know that these people are as corrupt as you can get. So now we've got to look at this and go, okay, Zellner, you're doing your job on the legal part, but who's going to help? How do we keep these people from doing this crap again to somebody else if there's nobody held accountable? Right? And that's the thing. You look at Wiegert, you look at Fallon, look at all these people, Norm gone. None of them seem to even blink an eye. And Kratz has disappeared. I'm honestly thinking, does Kratz exist anymore, or was he running his mouth too much? Because you're dealing with some very nasty individuals. So, Gold's Gym, hey, good to see ya. They say, we all think State Fallon are in on this, right? So when Fallon and the judge asshat sit there and litigate and posture, are they blatantly lying, or is it plausible not all state politicians involved? Good question. What I feel we should do is, at this point, there's crimes being committed, and I feel like we get this evidentiary hearing. It could prove that there was illegal behavior going on. Then I think we could maybe go after some names, Sherry Lynn Pontello says blood DNA on the back of the RAV unidentified. 823, big bloody handprint on the back of the RAV. Cargor, I can't talk today. Mars is in retrograde and my tongue is gone. Okay, guys, let's get back over to this. We're going to jump into part 4. The circuit court erroneously exercised its discretion in denying Mr. Avery's motion to vacate and motion for reconsideration and contradiction of the 2007 order by Judge Willis. Mr. Avery properly argued that the state's refusal to vacate its judgment violated the 2007 preservation and testing order. The state incorrectly asserts that Mr. Avery failed to raise the argument regarding the circuit court's violation of the 2007 preservation and testing order, claiming, quote, the argument appeared in none of Avery's motion in the circuit court. However, it did. In his Second Amendment supplement to his motion for reconsideration, Mr. Avery pled, quote, the effect of the court's failure to vacate its October 3rd, 2017 ruling is that it has unilaterally blocked all future scientific testing in the Avery case in the direct contravention of the April 4th, 2007 order entered by Judge Willis. The state cites, they're killing me, Sean Sheck versus Packard is in opposite, as it has not a post-conviction case, rather a products liability case in which a defendant manufacturer failed to mention even once that the plaintiff violated a Wisconsin statute until his appeal, Mr. Avery's newly discovered evidence in his motion for reconsideration. The state disputes Mr. Avery's evidence is, quote, newly discovered, citing to State versus Fosnell. To argue that, quote, newly discovered evidence does not include the newly appreciation of the importance of evidence previously known but not used. In Fosnell, the defendant's new diagnosis was merely the new interpretation of existing evidence. Similarly, in Vara, the evidence was, quote, newly discovered importance of evidence previously known and not used, where both trial defense counsel and the defendant knew of the defendant's head injury, which could have supported an insanity defense. Both cases are inopposites because Mr. Avery's newly discovered evidence does not consist of already known facts. Rather, post-trial experts revealed facts that were unavailable at trial. In denying Mr. Avery's motion, the Circuit Court erroneously applied the newly discovered evidence standard to mean that the test could not be available at the time of the defendant's previous motion pursuant to Wisconsin Statute 974.06 or any other appeals or motions filed after trial. The Circuit Court believed that the new evidence could not have existed before 2017. That is not the standard. When moving for a new trial based on newly discovered evidence, the defendant must prove, number one, the evidence was discovered after conviction. Number two, the defendant was not negligent in seeking the evidence. Excuse me. Pardon me. Number three, the evidence is material to an issue in the case. And number four, the evidence is not merely cumulative. State versus McCullen. Emphasis added. If the defendant can prove all four of these criteria, then it must be determined whether a reasonable probability exists that had the jury heard the evidence, it would have had a reasonable doubt as to the defendant's guilt. Here, Mr. Avery presented the following new evidence. Dr. Christopher Palnick, using a 2016 state-of-the-art microscope, examined FL and the hood latch swab, and his findings have produced new evidence that is totally inconsistent with the state's theory that Mrs. Halbach was shot in the head while laying on Mr. Avery's garage floor, and that the hood latch swab was actually used to swab the hood latch. Dr. John DeHaan, a forensic fire expert, determined that no body was ever burned in Mr. Avery's burn pit, based upon data he collected from his experiments burning human cadavers since 2012. Dr. Carl Reich was able, through the use of new source testing, RSID testing, developed after the trial to eliminate blood, semen, and saliva as a source of DNA from the hood latch swab, and offered the opinion that the DNA was consistent with what would be found on Mr. Avery's groin swab from his skin cells. Part 5. Okay, guys, I'm going to take just a few minutes here. I'm going to go to the restroom because my eyeballs are floating here. But if you are interested, you can go ahead and come back in a few minutes. We'll go ahead and give like a 3-minute break, and then we're going to come back in and we're going to read the other half. Now, I've got 1 hour, and that's about what we had for the first half. We did a lot, well, I did an immense amount of talking. So I'll try to trim down my narration part a little bit, and we'll try to speed things up for you. So we're on page 21. I believe it's like 45 pages. So we'll try to get through it a little bit further, and then we can come back tomorrow and really dig into like an open flat discussion where we just really dig into the parts that you guys want to go over. So with that, you may hear noises because I can't mute my mic in my bedroom. But if you do, that's going to be weird because I don't think there's any animals in here. All right, I'll be back in just a minute. You'll have to forgive me. I just had a bite of cheese because it was really good. So I need to take a drink real quick. Okay, let's see if everybody's back in their seat, and we will go on with part 2. Andrea Merritt says, aha, didn't know there was also blood. So many lies, and weed through this case. Thank you. True. Hey, Slayer Rock. Oh my God, long time no see. Good to see you. Skip the case numbers? Okay, will do. Good idea. Good idea. Thank you. Thank you. Thank you. Okay. With that, you guys, hey, James Zimmerman. Didn't see ya. Good to see. All right, guys. Part 5. And if you're following along, this is page 21. Let me grab one more drink. I feel I should gargle with something so that it's not rough sounding. The state mischaracterizes Mr. Avery's argument regarding trial defense counsel's ineffectiveness. The state mischaracterizes Mr. Avery's argument that the trial defense counsel was ineffective, stating, quote, in a nutshell, Avery argued in his June 2017 motion that Strain and Buting were ineffective because Avery believes he could have prevailed at trial if Strain and Buting had presented his, quote, planted evidence defense in the manner current post-conviction counsel formulated. Mr. Avery never argued that trial defense counsel were ineffective for failing to present his planted evidence defense. Instead, Mr. Avery argues that they were ineffective for failing to hire experts, failing to investigate and impeach Bobby Dassey, failing to establish third-party suspects, and failing in numerous other ways. Okay, so Hinton versus Alabama, where trial counsel was ineffective for failing to hire a competent expert, come on, to bolster his trial defense that the defendant was misidentified as the killer. The state cites Lee versus State for the proposition that permitting post-conviction counsel, quote, to argue a different game plan after contest is over would be Monday morning quarterbacking. However, Lee is distinguishable. Lee's defense was available at the time of the trial, but his counsel merely chose not to pursue it. Conversely, Mr. Avery is not arguing that his counsel could have chosen a different defense out of those available. Rather, he argues his counsel for ineffective for failing to hire experts or investigate. The state again misstates Mr. Avery's argument by claiming that Mr. Avery is contending the trial defense counsel should have hired his specific current experts, when Mr. Avery actually argues that trial defense counsel was ineffective for failing to hire experts in these specific areas of expertise: blood spatter, DNA, trace, ballistics, police procedure, forensic fire, and anthropology with curve mark specialization. Mr. Avery never argued that trial defense counsel should have hired his specific experts. Instead, Mr. Avery argues that the trial defense counsel was ineffective for failing to hire experts. Besides this, the state grossly mischaracterizes Mr. Avery's ineffective assistance of counsel argument as being, quote, that the quantity test results were both newly discovered evidence and that Strain and Buting were ineffective for failing to present them. The newly discovered evidence supports Mr. Avery's argument that trial defense counsel failed to present an expert to establish that law enforcement planted Mr. Avery's DNA on the subkey. The reason trial defense counsel did not discover the evidence was their failure to hire experts, which trial defense counsel admits. Thus, the state cannot, even by misstating Mr. Oh my fan just turned to another dial by itself and sped up. I swear I'm haunted, you guys. Whatever. Okay. Sorry about that. Thus, the state cannot, even by misstating Mr. Avery's whole argument, rebut trial defense counsel's ineffectiveness. Part 6, Mr. Avery's Brady and Youngblood claims are not barred because they were raised in supplemental motions. The state claims that Mr. Avery's motions are successive. However, per the appellate court's orders, Mr. Avery's motions are supplemental motions, and February 27, 2019 order. The law of the case doctrine is a long-standing rule that a decision on legal issue by an appellate court establishes the law of the case, which must be followed by all subsequent proceedings in the trial court or on later appeal. Even so, the state accuses Mr. Avery of filing in a piecemeal fashion. Filing under the same case number is, by nature, not piecemeal litigation. See, right there, she nailed it. Goes on to say, see Bannister versus David, where the Supreme Court recently held that the Rule 59E motion to alter or amend a habeas court's judgment is not a second or successive habeas petition, but rather part of the first full petition. Mr. Avery's motions and supplements were all filed under the same case number and are simply a continuation of the same proceeding. See Gonzalez versus Crosby. Issue preclusion doctrines are inappropriate where the record reflects that the petitioner is diligently pursuing his claims and supporting facts in his first meaningful post-conviction review. See Lonchar versus Thomas, holding that abuse of the writ doctrines have no application in a first habeas corpus proceeding, and Williams, holding that a prisoner who acts diligently to pursue his claims has not, quote, failed to preserve his right to a hearing on his claims. Mr. Avery has sufficiently pled his Youngblood claim. Even though it is undisputed that the state violated the notice requirement of Wisconsin Statute 968.205 on evidence preservation, the state claims that Mr. Avery cannot prove its bad faith and thus makes an insufficient claim under Youngblood. The argument that Mr. Avery alleges a statutory claim overlooks that Mr. Avery only uses a violation of the statute to show the state's bad faith in breaching its duty of notice. While the Trombetta and Youngblood evidence preservation doctrines originally applied only when evidence was destroyed pre-trial, the Wisconsin Court of Appeals stated that Trombetta and Youngblood and Wisconsin's two-part Greenwald test are applicable due to the post-conviction destruction of evidence in State versus Parker. The state claims that Parker should be overturned after, quote, a quick read. However, Parker has been followed and affirmed by numerous decisions and is void of any negative analysis. Therefore, the state's argument is devoid of any rational for overturning this court's prior decision. The bone fragments recovered from the gravel pit constitute apparent or potentially exculpatory evidence. The state misconstrues the apparent and potential exculpatory nature of the Manitowoc County gravel pit bone fragments. Mr. Avery presented the affidavit of Dr. Dehan that Mrs. Halbach did not burn in Mr. Avery's burn pit and her bones were planted there. Dr. Dehan opined that Miss Halbach was burned in a burn barrel, and it is undisputed that larger human bones were found in the Dassey burn barrel. The human scapula, portions of the spinal column, metacarpals, and long bone fragments. The Dassey burn barrel bones had cut marks. The gravel pit bones had cut marks. By destroying the gravel pit bones, the state prevented Dr. Symes, Mr. Avery's expert, from matching the cut marks between the burn barrel and the gravel pit, thereby establishing that the Dassey, did you hear me say Denny? That the Dassey burn barrel was a primary burn site. This evidence would establish a direct connection between the Dassey burn barrel and the mutilation of Mrs. Halbach and the subsequent planting of bones in Mr. Avery's burn pit. Clearly, the killer performed all of these tasks. Dr. Dehan ruled out tires as an accelerant. Dr. Eisenberg claimed that she detected the odor of a flammable liquid and not burned rubber from the bones in the Dassey barrel, which the state claimed was the accelerant used by Mr. Avery. Mr. Avery was deprived of the opportunity to link the gravel pit bones accelerant to the Dassey burn barrel bones. The evidence against Bobby of motive and opportunity is apparent. Additionally, if the gravel pit and the Dassey burn barrel bones had been linked, the state's star witness would have been converted into a primary suspect. Dr. Dehan opines that the bones in Mr. Avery's burn pit were planted after being burned in a burn barrel. Dr. DeHaan stated, quote, the discovery of larger fragments outside the margins of Avery's burn pit and finding a human bone fragments with similar degrees of fire damage in numerous other areas is also consistent with the, quote, dumping of burned remains into the alleged burn pit with some rolling or landing outside the pit. If Mr. Avery establishes in an evidentiary hearing that the primary burn site was a Dassey burn barrel and that the bones from that barrel were planted in Mr. Avery's burn pit, that evidence would be potentially exculpatory and would undermine confidence in his verdict. Mr. Avery has established that the state acted in bad faith. Quote, bad faith can be shown by proof of an official, animus, or conscious effort to suppress exculpatory evidence. Further, under certain circumstances, it is permissible to draw an adverse interference against the government when it destroys evidence. United States versus Davis, vacated on other grounds by 570 U.S. 913, bad faith can also be inferred from the fact that the prosecutor deliberately misled the jury into believing that there was no possibility of human bones in the quarry. In Jemison versus Payne, the Eighth Circuit held that the defendant established a young blood violation regarding a recording that was either lost or destroyed. The Eighth Circuit acknowledged, quote, without the recording, we cannot ascertain its significance. However, the fact that it existed and the state failed to disclose it demonstrated a, quote, conscious effort to suppress evidence. The reasoning in Jemison should be applied to Mr. Avery's case to find that the, quote, bad faith element has been satisfied because the prosecutor deliberately failed to preserve relevant evidence. All right, guys, I'm going to come back up before we do part 7. Let's see, how's everybody going? Gloria says, this whole case is crazy. Let's see. Sherry Pontello says, DJ, actually, they did deny him air before the trial. They turned the air on in his wing and opened the windows. He had to buy a fan and was burning up. Huh. Slayer Rock says, just like all pre-DNA convictions that were later overturned. I agree. Mary, thank you. She says, show some love, hit the thumbs up. We are a demonetized channel. Everything we do is absolutely free to everyone, and that's how we will remain. So with that, hit that thumbs up so that YouTube don't delete our channel, because with us not being monetized, we're really of no asset to them, and YouTube basically goes by algorithms. Without me being able to do as many lives lately with everything we got going on, and I needed to step back. I do. After going and visiting the locals and learning the hell that they went through, it did a number on my head, and I still have to get that video out there and share with everybody. It's quite intense to go to that level of being that deep and see true fear in people's eyes to their lives are just destroyed. It's heart-wrenching. It's very depressing. It made me feel like we weren't getting anywhere, and I really did need, and we all do. If you've gotten obsessed with the case and, you know, your family wants some time with you, let me tell you, this case is going to be here. Go take a breather. You deserve it, and we can, you know, we will carry your weight while you're gone, just like everybody's been carrying my weight and making sure that they're working on the case. So all right, guys, are you guys ready to jump back into I think we're on part 7. I'm just reading a few of these. Julian Dyer says, was Bobby or Scott in a vehicle alongside TH as nobody confirmed they were on their own? They confirmed seeing each other, but was TH a passenger? Oh, that's an excellent question. All right. Okay. Hey, Graham. Hey, Graham Moss is with us. And Raised by Gypsies. Yeah, I do hope you return. Thank you so much, dear. All right. Let's get back over to this. Part 7. Because Mr. Avery's factual allegations must be assumed as true, he is entitled to an evidentiary hearing. Mr. Avery's motion for relief was filed pursuant to Wisconsin Statute 974.06, which requires a hearing unless the motion and the files and records of the action conclusively show that the person is entitled to no relief. Wisconsin Statute 974.06. The statute requires that the circuit court holding an evidentiary hearing when the movement states sufficient material facts that, if true, would entitle the defendant to relief. In making this determination, the court must assume that the facts alleged are true. Because the circuit court did not hold an evidentiary hearing on Zeeley's motion, we will assume that the factual allegations in her motion are true. Even if the facts assumed to be true seem questionable in their believability, the circuit court must hold a hearing. State v. Lintner stating that when credibility is an issue, it is best resolved in live testimony. Further factual disputes may only be resolved at an evidentiary hearing. State v. Hamilton. So we're going on to page 30, which we have a chart here. The following chart illustrates the facts that must be assumed as true, from which Mr. Avery in the factual disputes raised by the state, which necessitate an evidentiary hearing. So it goes topics, facts assumed to be true, and state's dispute of Mr. Avery's facts. So this is a list of Brady violations. Ramlow affidavit, RAV4 planted. The Ramlow affidavit is true, and Mr. Ramlow saw the RAV4 on November 4th, 2005, illustrating that it was planted, and the state's theory that the RAV4 never left the Avery property is demonstrably false. Ramlow's affidavit impeaches Sergeant Colburn's testimony that he was not looking at the RAV4 when he made the dispatch call regarding the vehicle's license plate. Because trial defense counsel did not have a police report documenting Sergeant Colburn's conversation with Mr. Ramlow, they could not impeach Sergeant Colburn. The chronological of the 30 tracks of the MCSD calls to dispatch show that Sergeant Colburn's call was made on November 4th, 2005. So the state disputed that, quote, Ramlow seeing a similar car somewhere fails to establish any fact that the RAV4 being planted. Okay, let's scroll down. Let's see how we're going to read this. Not sure how to go about it, but let's try. So we're still working on that same Ramlow one. The photograph of the poster seen by Ramlow at the gas station included a photograph of Halbach's car. But the state says, assuming Ramlow's contentions are true, Ramlow never even knew what Miss Halbach's car actually looked like because he never saw a picture. So right there, she's proving that he admitted in his affidavit that he saw this flyer. Redundant. The affidavit of the RAV4 planted. The Redant affidavit is true. The Department of Justice agents knew that the RAV4 was planted on the Avery property. Mr. Redant's affidavit contradicts the state's representation to the jury that the Avery property was inaccessible from the Redant pit. Let's scroll and make sure there's nothing more. Nope. All right, now this is what the state says. Avery does not say who Redant had this conversation with when it occurred, what the context was, what this person's belief was based on, or why Redant did not tell trial counsel or anyone else about it in the 12 years between trial and his affidavit. There was a 20-foot berm separating Avery's trailer from access to the rest of the salvage yard and the Redant pit. So then she goes over to the flyover video. RAV4 planted after 11/4/2005. The flyover video was deliberately edited to conceal that the RAV4 was not present on the Avery property on November 4th, 2005. On November 4th, 2005, Wendy Baldwin, Miss Baldwin, and CCSD Sheriff Jerry Pogel conducted a flyover searching for the RAV4. They were in the air for around 4 hours, yet produced only 3 minutes of flyover footage. Prosecutor Kratz made a material admission when he told the jury that the RAV4 was not visible in the flyover video. The credibility determination must be made of the Kratz statement that the vehicle was not present. State says Avery's claim that the flyover video was edited was utterly devoid of facts and relied wholly on Avery's speculation that more footage must have existed because the prosecutor said the RAV4 was not visible on the video and the flyover produced only 3 minutes of footage. Zipper answering machine. Mrs. Halbach killed after she left the Avery salvage yard. This is what she's saying. The zipper voicemail was concealed because it was it demonstrated that Mrs. Halbach's final stop was the zipper's and not Avery's. Quote, the contents of the zipper voicemail may have contradicted the timeline established by the state that Ms. Halbach's last stop was the Avery salvage yard. Ms. Zipper testified at trial that Ms. Halbach arrived at the property at 3 p.m. The state places Ms. Halbach at the Avery property at approximately 2:30 p.m. So the state's statement was nothing about Halbach leaving on the voicemail at 2:12 p.m. stating that she can't find the zipper's house, but then later arriving at 3 p.m. does anything to contradict the timeline established by the state. Now we're going to scroll down. We're on page 33. Heidel's affidavit. Mrs. Halbach's day planner was in the RAV4 on 10/31/2005 and then in the possession of Ryan Hilligus. Ryan Hilligus is established as a third-party Denny suspect because he was in possession of Ms. Halbach's day planner. The state says there is no proof that this was Ms. Halbach's day planner. Now we're moving on to Detective Veli's CD. Detective Veli's CD contained new material evidence that had been previously concealed from prior counsel. Excuse me. The forensic findings and opinions of Detective Veli were entirely contained on the CD in his final report and not on the 7 DVDs. The CD contained recovered pornography, Avery's brief. The 7 DVDs did not contain the results of Detective Veli's unique search terms found exclusively on the CD. Those search results are as follows: 2,632 search results for the terms blood, body, bondage, bullet, cement, DNA, fire, gas, gun, handcuff, journal, MySpace, news, RAV, stab, throat, and tires. Let's see if there's more on the bottom of that. Bobby, okay, nope, that's going to come back to Bobby. All right, let's jump over to what the state said. Avery does not point to items of evidence he did not have that were on the Veli CD, but not the hard drive. He just complains that he could not have guessed what the search terms Veli used. Well, this state is done for you guys. This is so hard-hitting. I love it. So we're talking about the impeachment of Bobby Dassey's trial testimony. And here's the point. Bobby committed perjury at Mr. Avery's trial when he testified that he never saw Mrs. Halbach leave the Avery property. This CD contained exculpatory material evidence that was directly relevant to the credibility of Bobby and would have allowed trial defense counsel to allege Bobby committed the crime, and the state's failure to disclose it violated Mr. Avery's due process right to a fair trial. Only Bobby had access to the computer during the day on the weekdays when the violent pornography searches were conducted. Bobby's trial testimony that he slept from 6:30 a.m. to 2:30 p.m. was contradicted by current post-conviction counsel's expert, Mr. Hunt, who found that Bobby accessed the computer 6 times during that time frame. The state claimed Avery fails to explain why a single statement from Brian to the police that Bobby saw Halbach leave the property would have tipped the scales when the wealth of other evidence pointed at Avery and when the jury already heard multiple other accounts that conflicted with Bobby Dassey's testimony. Ooh. The fact that someone's views violent pornography does not diminish their credibility as a witness, as Avery claims. Okay, wait a minute. The state now is took the stance just now that if you're looking at violent pornography when a murder's committed in your driveway, that they don't feel that should have any conflict or even an interest or effect, anything going on with the investigation of that victim or testimony. Whew. Though distasteful, it has nothing to do with their truthfulness. Intent. Apparently, the state doesn't know what intent means. They continue to say, nor would viewing violent pornography refute anything about Bobby's claim that he never saw Miss Halbach leave the Avery property. What about when Barb stated it as well. Blood spatter expert Stuart James. The blood spatter in the RAV4 was selectively planted and did not come from an actively bleeding finger. All right? This is the state said this part. But James experiments simply assume a number of variables James cannot account for, such as how deep Avery's reopened cut was, how much a partially healed cut would have bled, how he moved about the RAV4, and the many other ways blood flakes could have ended up somewhere. So let me ask you guys this. Let's just forget about blood for a minute. So I'm going to give you a dropper full of red Kool-Aid. And you can have as long as you want, but you cannot drop liquid into the carpet, but you just have to put the flakes of the dried Kool-Aid on top. Good luck. Good luck. So now he's a magician. Okay, so he's a genius and a magician. No wonder they're so threatened by Stephen. Bullet fragments FL. Bullet fragment FL never passed through Miss Halbach's skull, as the state experts opined. The state's forensic pathologist, Dr. Jensen, testified that Mrs. Halbach's cause of death was the result of 1 or 2 gunshot wounds to her head. Dr. Jensen testified that Ms. Halbach's DNA got on FL when it traveled through her brain, causing her death. Dr. Eisenberg testified that there was no evidence of other gunshot wounds to the bones from other parts of Ms. Halbach's body. The state said, but contrary to what Avery claims, no one ever said that FK and FL were the 2 bullets fired into Ms. Halbach's skull. Avery made that inferential leap on his own. All right. Pretty soon, she's just going to have to get some crayons so that the state can, understand what she's saying. She'll just write "stop being assholes" with red crayon and hand them a helmet. I mean, I'm just seriously getting sick of the states. I couldn't even do the last brief. I tried really hard, but trying to read the last filing by the state, it was absolutely stupid. It was stupid. That part where it was like, and Avery's claiming that we didn't use Dr. Han and we didn't use, no. Avery's never claimed that we need the exact experts that he's using now. It's like the state doesn't get it. They're like a little kid and the parents like, go take a shower and you have to yell out and use soap. It's like, how damn stupid. And the thing is the state isn't stupid. It literally is talking itself in circles because the truth is coming out and it absolutely doesn't know what to do. They're scared shitless. Groin swab planted. The groin swab was substituted for the hood latch swab by Investigator Weger. Investigator Weger hand-printed Deputy Hawkins' name on the form, again, deliberately misidentifying Department Hawkins, or Deputy Hawkins, as a submitting officer, which was a complete misrepresentation. That should be grounds for firing someone, and he's the sheriff now. No, he's promoted. Yeah, promoted. The state fails to acknowledge the significance of Investigator Weger signing Deputy Hawkins' name on the Wisconsin State Crime Lab form when he delivered the alleged hood latch swab. All right, so this is what the state had said. Let's see, Avery based this scenario entirely on the failure of the nurse to note on her report that the groin swab had been taken but discarded, which according to him, a well-qualified nurse would have done, and the fact that Weger and Fassbender instructed Deputy Hawkins and Sergeant Tyson to swab the hood latch, battery cables, and interior and exterior door handles, but did not include the interior hood release lever and hood prop. Hilligas's evidence. Trial defense counsel was ineffective in failing to investigate Hilligas as a third-party Denny suspect. It must be assumed that Hilligas was in possession of Miss Halbach's day planner. Avery provided nothing establishing that the abusive relationship Halbach supposedly was in with Hilligas. with that Hillegas knew about Halbach's sexual history with Blodorn, and if Hillegas did not know about it, that he cared. Avery just proclaimed with no evidence whatsoever that Hillegas committed perjury about it. There is no proof that this was Miss Halbach's day planner. Easy peasy. The state's just being dumb. Sub-key planted location. Bookcase experts demonstrate that state trial's theory about the discovery of Miss Halbach's key in Mr. Avery's bedroom was false. State stated, importantly, the experiment key and lanyard were also to be pushed through the back of his experimental bookcase by striking it with the photo album. Sub-key planted DNA quantity. The sub-key was planted in Mr. Avery's bedroom as evidenced by the bookcase experiment and DNA quantities. Quote, Dr. Reich opines that the DNA found on the Toyota sub-key found in Mr. Avery's bedroom was planted. Dr. Reich conducted experiments which demonstrated that Mr. Avery deposited 10 times less DNA on the the sub-key than what was discovered by the Wisconsin State Crime Lab and used to convict Mr. Avery. What the state said was, what Avery glossed over was that he undeniably left his DNA on the exemplar key during his experiment. Avery's brief, which again was obviously conducted in a controlled environment and cannot account for the many other variables that could lead to Avery depositing more skin cells on the key, and with Avery in a different physical condition than one would be trying to hide evidence of the murder. Significance of subkey. Dr. Reich opines that the DNA found on the Toyota subkey found in Mr. Avery's bedroom was planted. Dr. Reich conducted experiments which demonstrated that Mr. Avery deposited 10 times less DNA on the exemplar subkey than what was discovered by the Wisconsin State Crime Lab and used to convict Mr. Avery. Sounds like it's a second thing. Second, like his... Okay, so this is the state's part. Second, like his hood latch experiment, Avery's experiment holding an exemplary key bolsters rather than weakens the state's case. Okay, we were talking about hood latch and subkey. Gotcha. How much longer, Papa Smurf? Because this is just so blatant, Electronic devices planted. Current post-conviction counsel's investigator conducted a series of experiments refuting Mr. Fabian's trial testimony that on October 31st, 2005, he was in the vicinity of Mr. Avery's burn barrel and smelled the distinct odor of burning plastic coming from Mr. Avery's burn barrel. Let me grab a drink. Avery's experiment could not account for environmental conditions on October 31st, 2005, any sensitivities of Mr. Fabian's, or the fact that Avery clearly put other items in the barrel as well. Destruction of the bones. The circuit court erred in concluding that the Manitowoc County gravel pit bones were non-human when in fact the Manitowoc quarry bones were labeled as human by Dr. Eisenberg in her reports, describing property tag number 7411 calcined human bone fragments, 7412 human and non-human bone, 5 and 13 burned calcined with cut edges. Most bone fragments or all cut bone fragments are human. 7413 one burned human fragment, 7414 burned calcined human bone fragments, 7416 human bone fragments, human is calcined with one cut edge, and 7419 cut burned human bone. And the state had said none of the fragments recovered from the locations in the quarry were positively identified as human, let alone the remains of Teresa Halbach. Brady violation, lending to Youngblood violation. It must be assumed that there was a Brady violation when the state failed to disclose the police report. The failure to disclose the police report led to the destruction of the gravel pit bones, of which prior post-conviction counsel was unaware. There must be an evidentiary hearing to determine whether prior post-conviction counsel knew of the specific bone fragments that were given to the Halbach family. The state said the state has conceded that there would have been a Brady violation if prior post-conviction counsel did not know of the evidence that was destroyed. Conclusion. For the reasons stated herein, Stephen Avery respectfully requests that this court grant him one of the following alternative remedies. Number 1, reverse the orders denying post-conviction relief, and remand for the state to file a response to the motion for post-conviction relief and order additional scientific testing per the September 18, 2017 agreement, and or grant an evidentiary hearing. Number 2, reverse the judgments of conviction and orders denying post-conviction relief and remand a new trial, which is what I'm hoping for, you guys. And that was dated 25th day of June 2020. And that is it, folks. Let me come back up to top side. Hooey. Carrie Smith says, Graham. Oh, this is flying. Hold on. I got to try to catch up with you guys. Woo. Okay. Carrie Smith says, Graham, I'm not sure when blood, etc. was searched. It doesn't show dates on the reply, but there were so many searches for all things relative to this case. And keep in mind, on that computer, there was a file that was named Teresa Halbach. There was a file that was named Stephen. And there was a file that was named DNA. Now, if it isn't somebody that knows Stephen, why didn't they put Avery behind it on the file? And what the heck? I think I have a kitty cat in my room that I didn't know about. At least I hope so. So, let's jump over here. What you guys got going on? Let me show that. Andrea Merritt says, my guess is on her having been killed over at Cuss Road site. So whose phone records line up with that location? Bobby Dassey's, ladies and gentlemen. Yep. James Zimmerman says, the Bible says, whatever you feed in your spirit, you get out of your spirit death and destruction. Oh, Bobby, you have some explaining to do. Oh, yeah. Hi, Liz Schultz. How you doing? Says, yes, Teresa, same guy wrongfully convicted and in prison twice under many of the same law enforcement. Optics don't look good at all. Definite corruption there. True. Pseudo DNA says, thank you, Julian. It's just something that came into my mind, never hearing or reading a good theory of events that day and the days after regarding St. Scott Tadich. No evidence is if trying to convict him. Julian Dyer brings up a good point. Could the CD be a red herring to hold over Bobby to give evidence about SA? You know, I've always said I find it interesting that Scott Tadich is noted by Brian Dassey of coming in to the relationship with Barb months and months, excuse me, prior to October, when Scott claims he doesn't even know these children's names. And Brian Dassey hinted that Scott came into the picture in like 6 months earlier. So that would put us somewhere between like April, May, I believe, of that year. And that's when we start seeing these weird searches. Yes, Bobby works nice. Yes, I know Zellner says Bobby's the only one that has access to this computer. But it didn't start off being in Bobby's room. It ended in Bobby's room. So it started off in the family room. Now, depending on how slick this ST, Scott Tadich, is in getting weaved into this family, is it possible by the time that computer got put into Bobby's room, by then manipulation had already started that was grooming and blackmailing these kids like Bobby into getting involved in possibly killing, possibly covering up. But is it possible that Scott Tadich had access to that computer? That's always been a question I had. I don't know. I find it interesting. Somebody made a comment the other day, not too long ago, because I'm still reading your comments as often as I can, that they themselves have had experience with people that have been addicted to meth. And they said that when people have meth, you'll see very obsessive personality. And they referred to the fact that the searches will go like 2 weeks, no searches. And then all of a sudden, there's this obsessive compulsive, just depraved search after depraved search all day long, all day long, all day long. And that they suspected, this individual stating that they suspected that it looked to them, in their opinion, that it was possibly like when somebody was getting a hold of meth, they would do this horrible searching and stuff. Now, it's all, speculation and hearsay, but I found that interesting to think about. All right, guys. Hey, we made it. It's 1:11, and I'm not going to be late for work, so that's really good. Myra Pennington, good to see you, love. And she says, I have to wonder how these searches were made before her death when they used Brendan's confessions to find all of their supposed evidence. I think they played with that, too. Yeah, I'm sorry about the state's reply. I tried, you guys. Like, I did a couple videos, and then I just couldn't get into the state's response. I felt like if I had to read the entire twisted, demented thing, that I would not be able to afford to pay my rent because I would need therapy for my controlled rage of their stupidity. And I'm like, I don't need more therapy in life. I don't have any. I don't need to start it. And that's what the state did to me. They trying to read their jargon was so infuriating that if it would have been printed, I felt like printing it and shredding it and watching each piece of paper shred, because it doesn't even make sense. Through their own omissions, they broke the law. They failed the law. They misinterpreted the law. They sound like a first year student in law. I have more sense than that, and I have no legal training. So it infuriated me. It actually pushed me to the point I just got my throat chakra just locked. I couldn't talk about it. And I'm like, I can't do these videos. When I saw Zellner's reply last night, I was very anxious to get on there. But like I said, the dynamics of my family situation, because of, for lack of better words, we've kind of taken in some extra family members, adoptive family members that are very young that need some housing right now. And so me and the boys decided, you know what, we may not have a big house, but there's plenty of room. And so our family dynamics have been changed up quite a bit. And then, like I said, lo and behold, here comes my ex after 8 years of not talking. And we're starting to kind of get to know each other on the free time. So the free time I did have, and then going to the local and going through all that, it is so depressing to think that these people's lives locally live in a hostage format. They can't even trust going to the stores to get a normal, day of groceries and whatever you got to do out there. They could be baking cookies and having a normal day, and if they're on the target list for being bullied, they'll get that wellness check. Police department, open the door. County Police Department, yep, open the door. No, Gretchen, mommy's playing. My dog's like, somebody in the bedroom? And so for them to have to live their lives like that and to see it firsthand, it was literally more of a wake-up call than I could handle. And I'm still trying to readjust, to swallow down how I felt in the very short time I was there. I was nervous. Me and Jim Thyro got out, and we pulled over on the side of the road, and it was a good place to park. It had a little driveway. We pulled in, pulled up there, and I get out, and it's not even got a house on it. It's just where an old house stood that I found very interesting, because John Ferret kept having Jim Thyro take him to the same location over and over, and we never knew why. So he's like, I really want you to see this house. We get there, and it's gone. The house is gone. There is no house. It's been plowed over, and it's gone. So we get out of the vehicle and I walk up the driveway and Jim's kind of following me a little bit. There's no signs that say I can't be there or anything. It's fine. And I go up on the property to look and see where the cement's all piled, where the place was. And people are stopping. They just stop. And they're like, what you doing? And I got nervous, The guy's like, what you doing over here? Like, they watch their properties. So I've seen it firsthand, where, you don't get to do anything in those areas without suspicion following you. They're very bizarre. If ever you go to those areas, let me tell you, make sure you have everything legal on your vehicle. I sure did. And I didn't tell anybody I was going. And I didn't tell anybody I was coming back till it was over. Because I was like, I don't want to go there again. I went there. It was okay. But the way they have to live in frustration, we need to back the locals. And let me tell you, what you think you know, you have no clue. So as a local, start trusting you guys. And they start telling you things on the channel. Firsthand, eyewitness stuff. Or the victims themselves talking about it. Trust me, they're not pulling your leg. They are being honest. They are being extremely honest. I will ask you to stand behind Local Motion. And that's Courtney Skinner, Jim Thyrell, Kim Ducat, Stacy Zipper, Corey Zipper, Dassey. Those are the ones that have come forward. And now we have Carrie on board too. Those are the ones. Let me grab a drink. That are willing to be publicly acknowledged. The rest of those locals are so terrified, they just stay in the shadows. They'll communicate to the other locals. They'll have meetings with them. It's very hard for them to get even the locals to talk to locals. They'll say things like, off record only, I'll tell you anything you want to know. But you can't hardly get anybody there to open up. And you can say, well, what's the deal? Why don't you want to go on record? And they'll say, are you nuts? I value my family and their lives. So you can't really, just assume that the locals are lying. When you get so many locals with these blueprint stories, it's like the mafia. It's like the mafia there. Let's see what else we got here. And then I'm going to jump off here and get ready for work. So let's see. What do we got? James Zimmerman says, maybe Bobby's afraid Scott might kill his mom if he tells the truth. Knows he's capable of killing. The girl must eat at him. James, you've nailed my whole worry. You nailed my whole worry. Everything. You put it right in there. Andrea Merritt says, Kim, oh wow, didn't hear that. Let's go back up. Kim Eastwood, hi, how you doing? Says, what I hadn't heard before and has concerned me with the CD is that Bobby's searches included Rav. Yep. For real. I prefer not to say Bobby searches. I know that's Zellner's strong point, and I stand behind her, but I'm not in a court of law. And honest to God, after I've looked at the way that things are done, they pick a patsy and they freaking frame that person to the T like Steven. So they probably had a backup plan for Bobby to be the accomplice. But Bobby, they decided, you're either going to be the accomplice or you're going to be the murderer. Or you're going to testify against Steven the best you can. And that's what I fear that Bobby was under pressure of. And until his DNA and Teresa's DNA show up mixed somewhere, I just can't lock him in because of what they did to Steven. And the cops are always after the Averys. What I personally suspect is basically Scott Tadich. And I believe Barb is a hostage. And I believe that, if anything, why would Scott's trailer have gotten burned to the ground? Why was Bobby Dassey noted by Blaine Dassey while on the school bus, which means that's between 3:30 and 3:45, driving a green Ford Ranger, which matches the exact description of Scott Tadich's. So who was driving Bobby's truck that followed the victim out of the actual salvage yard or, Avery Road? Who really was driving that? I don't know. But there's so many questions about Scott Tadich. And if you do want to know about more information about why we have suspects, like why we would think that Scott Tadich was a suspect, jump on over. And we have 24-point conflict on pretty much, I think, 8 people or something. I'd like to get back to doing those too. Hey, Liz Schultz. I believe victims. Yes, and that's what I'm saying. When the locals started to come forward, it was terrifying. And I'm going to make this very clear. And I'm going to give you guys a little tip of what it's like to be a rubber ducky. All right? Unfortunately, there have been differences of artistic opinion in the way that information is relayed to the public. I like to come on, do things my way. I like to discuss anything right away. I can throw together graphics pretty quick. And so over time, some people got mad at me, and a lot of people got mad at me that would join groups that would want to go work on projects for a year. I don't wait a year because I think of Brendan kind of like one of my own, and every day he sits there drives me nuts. And so I'm a hurry up and get it out there and let the people work it out. Let them dig in deeper. I'm not here to solve the puzzle. I'm here to relay information, whether it's complete or not. So that's been a big issue for me, is that people want to work on things for 6 months to a year, and I want to get it out there today, right? So a lot of roughness had gotten around the edges where I've ignored it and walked away and done my own thing. And there's been a lot of people that have accused me of stealing stories and all kinds of stupid crap, when actually I have no idea if I stole their story, because I get emails and crap every single day that say, have you heard this? Here's a link, read it. I don't know who's working on what. You know, if you're in your basement working in the dark for 6 hours and you're doing it for 6 months, how am I supposed to know that's what you're doing when somebody emails me the information? I go online, I blow it out on a live, right? So I ruffled a lot of feathers. So then when I brought on the locals, they ended up taking the brunt of a lot of hate, a lot of haters, and getting chewed up and spit out, which was a crime in itself. Because you should never judge a case by personality faults. Even if you hate the duck, which is your prerogative, just stay off my channel. But don't harass the locals, for God's sakes. For real. And so I owe the locals so many apologies because of haters that are mad at me because they think I steal their crap, when I don't know who stole your crap. All I know is it came to me, and I think information that's online is considered public. Yes, I have tried to give credit where credit is due. You can go back and watch videos where I'm like, thank you so-and-so so much for giving me that. And yet in the post, they'll say, why didn't you give me credit for this? And I'm like, here's your crown, here's your cookie, gold star, thank you. Because why is this about credit? Why are people acting like that? So to ask you nicely, if you're listening, please keep focus on this case and make it about the locals, and don't make it about petty crap. Isn't there some saying about don't sweat the petty stuff, pet the I don't know. There's something. Just get over yourself, okay? Treat these locals with respect. Treat them with care. That's all they're asking. And you protect them, because if a local comes forward and you guys shun them, they have risked so much coming forward to try to enlighten Zellner and others about this case. And if we don't have their back, how do you think the other locals are going to do coming forward? You know? So work with them, please. And I want to say thank you so much for joining me today. I missed you all so very, very much. Let's see. Julian Dyer. What if the RAV4 was embolished on salvage yard and ST gave TH a lift out to the next auto trader photo ship? Then things went wrong. I don't know. I feel like something went down on Cuss Road. I'll tell you that. Liz Schultz says, Ronald, yeah, it wouldn't be hard to swap a hard drive. You know, a long time ago, I took so much heat for this because I was like, you know, to me, I've taken a computer apart and had to put in a new hard drive or a motherboard or whatever. It's like 4 screws. If I went to your computer right now, if you have a hard drive and I pulled that piece out and I put it with, you know, one other on the table, can you tell me which one's yours? How do we know that's not King Kratz's own hard drive? Or how do we know that that's not Scott Tadich's own hard drive? The only way we could know is if that hard drive was still being maintained in evidence and we checked the IP at the time of the searches. You know? Did some pinging on the computer, but you can't do the pinging because the hard drive's out. It would need a timestamp, which we have, but it would also need the IP that validates that it was at the internet service provider fingerprint ID location. So, Sudo says they're jealous of me. I don't know what they are. I don't care. I just stay on my own game here because, really, honestly, if you have time for haters, you're not working on the case right. So every minute that I do get on the case, it's about information. It's about you guys, getting the information to you guys. I come on sometimes and I have wild, crazy ideas, but it gets you thinking and you guys dig in, and that gets how many more people looking at this case and keeping Stephen and Brendan in the news, in the eyes of the world, and protecting them. Andrea says, it's all about Avery's freedom, not a damn cookie. Thank you. Amen. Amen, Sister Passabutta. Let's see here. RD, okay, Carrie Smith says, RD, love the 24 pointers you do on individuals. Give plenty of ideas. Thank you. Oh my God. Andrea Merritt says, Ducky says, don't sweat. You hear that, Kratz? Because we know you're watching. That's cute. Kimberly Bomber says, a lot of people are selfish and so into getting applause that they forget that this team effort to correct wrongdoings. Let me tell you something. When people want credit for something, I have a hard time giving it to them unless they have designed like some dot to dot, because just providing a piece of information, even if it's a FOIA, I have a hard time handing out credit, because it's kind of like when you're looking for your other sock and somebody finds it and hands it to you. Yeah, thanks. Okay. You're not going to be like, thank you, Mark Anthony, for finding my red sock. No. You're just going to be getting the job done. Get your damn socks on and move on. This whole I need a cookie for every little thing I do is bullcrap. Look at those online that work their asses off and they don't even ask for any credit. And yet I admire them so much. I mean, AC, I mentioned him earlier. I pay attention to him, and I have never once heard him complain that he doesn't get credit. You know why? Because he doesn't care. He's here for the truth of the mission. And that is that truth train coming through every day, plugging away to make sure that nothing escapes us in this case that proves another way that Stephen and Brendan are innocent. And we know that. Jennifer Manning says, I totally understand what you're saying. I listen to who I want to. I don't really don't care what people say. More info I hear, better grip I have on this case. Great work, RD. Thank you. You know, and I have no grudges against any of these people that may have grudges on me. I honestly don't. I wish you all love. I wish you success. I hope you wake up every day and you're just so damn happy that you're shitting lollipops. I really do. Because if you're happy, you're going to work more on this case. And if you think the information's coming out too soon, let me remind you something. Let's go. Okay, that's my work alarm. So I got to get ready here soon. But let's go to this brief. I want to tell you why I don't want to hear another person ever say to me personally that they've been working on anything in this case for 6 months and they're offended that I brought the news out too soon because of this. Stephen Avery, Mr. Avery, has spent 5,343 days behind bars for just the second wrongful conviction, right? So don't tell me you need 6 months to do a little thing about something. Just get it out there. Or I did you a service and saved you another 6 months because you're dragging your ass on the carpet and just not getting your shit done right. You can't call yourself a researcher if it's taking you a year to produce a tiny bit of evidence. Okay? So, yeah, hate me for working on the fly. I can't help it. But I love you all. I love you all. And I support every single person's channel. I support every single person that is mentioning Stephen, mentioning Brendan in a positive light, and getting it out there that they're wrongfully convicted. Whether it's foul play, Millbilly, Eric Cozy, Paul Capaldi, Bruce McGuire, Andrew Whitehead, Grandpa, Richard. He gets a little crazy at times, I know, but he's a grandpa. He's got some things he wants to talk about. Let him talk about it. I mean, he still brings attention to the guys, right? And he does have some valid points. I seriously believe him when he says there's 2 Rabs. I absolutely believe him 100%. He does a lot of work with different companies. He's got some great points. So you kind of have to sift through his own narration a little bit, get familiar with his language. But truthfully, we're a team, no matter whether you like it or not. So I love you guys so much. I really do. I've been getting into a little bit of trying to understand like how far up the ladder of corruption, not related to Stephen Avery necessarily, but just actual corruption this ladder goes. And it pretty much goes right up to the who, Bill Gates and that crap. And so if you're interested in that channel, I haven't been adding any new ones on. I haven't been doing anything but working my butt off and trying to manage family time here. And I'm still going to be on vacation until the month of July. About mid-July, I'll be coming back on, hopefully strong. I should have a new area that I have my YouTube stuff on, as well as our channel will get updated. But I love you guys so much for staying with me. It means the world. Thanks for checking on me, because I do get a little nervous that, if I get real quiet, that they'll be like, shut that duck up, right? So I do appreciate you guys checking on me. I want to give a shout out one more time. I want to say that Dave Bogata, you rock, man. I just think so much of you, and thank you for having the conversation with me about Brendan's calls. I wish I had time that day to do a live with me working and stuff. The hours I'm putting in right now are insane. 18-hour shifts and 24-hour shifts. We've got a lot of short staffing going on, so it's been a little bumpy, but I do love you guys. Hey, Hazel's here. Good to see you. I hope I didn't miss out on anybody. Hey, Kim Eastwood, in case I didn't say hi. Yeah, I know, Kim. She says, what's the deal with Richard Boyd? I can't quite work him out. Something's making sense, but I can't bear the slagging off. Yeah, you just have to look at him as a grumpier old man. He's got good points. He's not as soft he's not soft spoken like the rest of us. He gets very blunt and to the point. So much love to all of you, and hey, I'll see you again soon, I promise. I'll try to get on here maybe tomorrow, and let's break down some of this a little bit together and just have a big old chat about it. Much love, everybody, and be well.